Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, welcome back. Jeff Roberts, welcome back as well, buddy. I'm glad to see you again.
Good to see you, Jim.
Absolutely. Glad we were get together. Today, we're going to talk about premises liability, and that seems like a complicated term, but really what we're talking about is injuries that may occur on somebody else's property primarily.
Correct. And normally you're referring, at least most of the time when attorneys refer to that, they're talking primarily with a business.
Okay. Yeah. And so a common example of this might be if I go into a Lowe's or a Home Depot or some other large store and something falls from the shelf and causes an injury to me. I mean, that's a premises liability. If I slip in the aisle or I trip over something that should have been cleaned up or should have been addressed, it's improperly marked, even in the parking lot. All of this kind of qualifies, right?
Correct. It all qualifies. And like I said, when we normally think of premises liability, at least from my perspective, I think of a business, but it can be a residence as well, where, if there's a danger at the property that causes the person a physical injury, then you can pursue a premises liability claim even against a residential owner.
So we're out on the back deck, I'm leaning against the rail on the deck, and it gives way, and maybe I fall down and break an arm or a shoulder or something like that. That's premises liability.
Exactly, it would be, yes. From that perspective, that's what you're looking at. That's what homeowners insurance is for, or one of the things homeowners insurance is for. From that standpoint, but where you tend to see the cases again is in the business, like you talked about the falling merchandise. That's one type of premises liability, and you'll see now a lot of businesses that have items stacked very high, overstock or whatever, that they put on the very top of shelves, like Lowe's and Home Depot in those type of stores.
Pallets full of boxes and things like that.
Yes, and when they're doing work on one aisle with a forklift, they'll block that aisle off. But you're seeing, at least I'm starting to see much more frequently now, that they'll block off if they're working on, if you're looking at the aisle and they're working on the aisle to the left. They'll block off the other side of that aisle as well, because if they bump that shelf, merchandise can fall over and strike a customer or an employee who's working in that other aisle. And I've handled both the workers' comp perspective if it was an employee, the customer perspective if it was a customer who was unfortunate to have an item up over their head fall down and strike them when they're shopping.
Now, we've all been in different aisles, and they say, hey, look, if you're trying to reach a shelf overhead, call an employee to do that for you. And really, that's part of that, right? They don't want you trying to pull down something and then suddenly boxes tumble, and you've got a head or a neck injury or sometimes worse, right?
Yeah, correct. And if they've got, from my perspective, if they've got to sign up, ask an employee to get anything down off the top shelf, and you start, climbing the shelves like they're monkey bars, and
I gotta forget not to do that.
Yeah, exactly. And something falls over, you're going to be probably the one at fault in that setting. Now, Kentucky jurors are actually allowed to apportion fault, and if they found the property owner to be 1% at fault, the property owner has to pay 1% of the damages from that, because Kentucky is what's called pure comparative fault in legal circles. But if you're up climbing around, then you're probably going to be responsible for your own medical bills in that setting from there. And that when we talk about falling merchandise, we're talking about stuff that's improperly stacked.
Yeah, you see that often.
Yeah, improperly stacked and it falls, or they're doing work on one side and they bump the thing and it causes merchandise to fall off on the other side. At least when I say falling merchandise, that's what I'm normally referring to.
Well, I used to run some operations where we had a warehouse. We had a lot of inventory, and we didn't do as much training with the staff out there as we probably should. And sometimes some of the sales guys would run back there and jump on the forklift and grab something or place something just to help speed up time. And we're not properly trained for those kind of operations. So again, we're creating a situation where there's some inherent liability. should somebody get injured.
Oh, absolutely. In that setting, if the person not properly trained on utilizing the forklift, that can increase the liability. Not really increase the liability, but it establishes the liability even further from that standpoint, because you can only be 100% liable. You can't be any greater than that. But that's one of the things that can come into play in proving liability on the store or the warehouse is, the person operating the forklift was not properly trained. And someone who's properly trained shouldn't be going full speed ahead into a shelf.
Right.
And so you can, those are things that the attorney would want to look at when they're handling those type of claims.
And, sometimes out in the parking lot, there's potholes, there's other things, or things that aren't marked as well. And a fall or an accident can occur out there. How do you begin figuring out who really is at fault for that and who's actually liable for that type of an injury?
Well,
or damage?
Yeah, to some extent, it's going to, as a practical matter, come down to how long it's existed. If you have a customer in a store, inside or outside the store, that spills oil, creates a slippery thing, and then 2 minutes later somebody slips and falls in it. The store is more likely, at least most jurors are going to find the store is a little bit less likely to find fault with the store from that setting, unless it's if you can show it's been a repeated issue over and over. It's AutoZone and they sell oil to the customers and say, yeah, just go put it in out there in the parking lot, go ahead and put it in, and don't go help them and make sure they don't spill it everywhere. Then that can make a difference. From that standpoint, if the substance, the slippery substance, has been on the floor for a couple of hours and they just employees have walked past it and not done anything to clean it up.
Nobody's put a cone out or anything saying, hey, this is
nobody's put a cone out, done anything of that nature. Then obviously the fault of the business increases in that setting, certainly. From there, in every one of the cases I've handled, especially for in regard to slip and fall type of injury, is the business will try to point the finger at the person who slipped and fell and said, well, if they had been watching where they were going, they never would have slipped and fell. But when you talk to the merchandisers and you talk to the store managers in depositions and things, you can. One of the things that stores do is they try to get you to look at the shelves and not stare at the floor while you're working. They want you to look at the merchandise, so you're buying something that's not on your grocery list, for instance. They kind of design the stores to draw your attention to certain things and keep you from doing that, to looking at the floor. So you've got to. One of the things that the attorney at least needs to be doing to counter that is to making sure they're getting that evidence that the store was trying to get you not to look at the floor.
Right. And in other cases, a lot of the stores now, if you look around, actually have security cameras all over the place. And you might be able to get time-stamped footage from their own internal systems, right? Yes,
you can. A lot of those can be written over, and some places have them where they're on a loop, so they do write over fairly regularly.
About every 15 minutes or 20 minutes it starts again.
Most of the time it's a little longer than that. Yeah. And that's one of the reasons you want to go see an attorney early on, because if in the normal business practice that is written over every 30 days, and they normally write over that video, they don't preserve the video, there's probably not much that we can do about that. But if you have an attorney that knows what they're doing, one of the first things they will do is send a letter out to the insurance company, the business, and preserve any and all video or photos or anything else you have of the accident scene in the time of the accident or time of the fall. And then if they override it after that, then in Kentucky anyway, the judge can instruct the jury that the jury can presume that the video would have been favorable to the injured party, not the store.
Wow. Yeah. Wow. So that's to their own detriment to actually do that.
If they do that. And which would be the reason You know, if it supports, there's never been a video lost or written over that supported at least in my cases, that supported the business owner. I've had several of them that say, well, we don't have that video. We can't find the video at times. But anytime the video showed that the customer 3 or 4 times, 3 or 4 in front of my client, dropped whatever it was on the floor, and then a minute later my client comes along and slips and falls. That video never gets lost.
Right. Amazing, isn't it?
Yeah, it's just amazing how that works from that standpoint. Yeah. But and I have had videos provided to me that showed the item had been on the floor for a long period of time.
And that could, for instance, be at a Kroger or a dollar store or something like that, where there's maybe a spilled dishwashing liquid or some other kind of soap or something. It doesn't just have to be oil. Anything that causes, it could be water actually, that causes a dangerous environment, and somebody falls and is injured, right?
Correct. Yeah, anything in it. It can be a piece of paper, because paper on certain floors can be very slick. And so anything on the floor.
You used to pass a lot of notes in school, didn't you?
Well, I was good at it. I didn't get caught though.
Friends, if you've listened to this if you've listened to these episodes long enough, there's always an attempt to try to get Jeff to laugh and get off his game, but he's pretty good at bringing it back.
Yes, and vice versa. But yes, anything like that, any hazard and sometimes it can just be the merchandise is sticking out into the walkway.
Right. So a trip hazard of some sort.
Trip hazard from that standpoint, and so any hazard there that the business created or should have known about and didn't correct can be can result in liability on the business owner.
Okay, so we're in the middle of summer when we're recording this, but let's fast forward to winter, which I know we're not looking forward to. But assume I pull into a parking lot and there's a lot of ice and snow out there, and somebody falls or somebody doesn't see a pothole and turns an ankle and falls and causes an injury. How do you address that? I mean, because, again, it's winter time. So walk us through that.
It kind of comes down to a reasonableness standard. The laws in Kentucky have kind of evolved over time on that, and that's kind of a sore subject with me that I'll explain in a second. But they have evolved over time. If the and it comes back to reasonableness on and ultimately it can be a jury determination. At one time, the law was that if it was a naturally occurring substance, outside substance like snow and ice, then the business owner did not have to correct the problem or warn about the problem. And there was one case at the Court of Appeals that said that if they undertake, while they don't have to correct the problem, if they undertake corrective measures and it makes it more hazardous, then the business owner could be liable. So if they clean snow off and leave black ice and don't do anything to treat the black ice, then that could create liability for the business owner. And that's kind of what the law was when I first started practicing law 28 years ago. And why it's kind of irritating to me is when I first started practicing law, I started practicing with another attorney, Don Jones, and I was sworn in October. Christmas Eve or Christmas Day 1, I was here in the office working on a brief to a petition for review with the Supreme Court of Kentucky, because he had a case where, and I can't remember I want to think it was Kentucky Oak Small, but I'm not positive who the defendant was. But he had a case where they had taken corrective measures and at least appeared to have made it more dangerous. And he got summaried out by the judge. That Court of Appeals came out after the circuit court had kicked him out. And the Court of Appeals panel in his case basically said it doesn't, it's naturally occurring. It doesn't matter if they take any corrective measures or not. And so we were appealing up, and the basis for appealing it was there's a split between the Court of Appeals. One panel said there was liability. Our panel said there wasn't liability. Both were supposed to be reported cases. And the reason I'm irritated about that, because I worked that Holiday working on that brief in the Supreme Court basically said, well, we're depublishing the Court of Appeals opinion in your case, so now there's no conflict. We're not granting review of the case. And I was not. You talk about having your the wind knocked out of you. I was not a real happy camper when I read that one.
Now, Jeff, that was only 28 years ago, my friend.
And you can still tell it still irritates me a little bit from that standpoint.
Right.
But yeah, the law has evolved over time from that to where it's not an absolute bar to pursuing a claim if there's snow and ice. It's going to depend on a totality of the circumstances from that standpoint. So to give you a bright line rule, I can't, because I don't think there is a bright line rule right now.
Right, meaning something that this is definitely when it becomes a liability versus when it's not. It really doesn't exist at this point.
It does not exist. I mean, if it's a ice that's been that's been in existence on the parking lot for a week and they've done nothing, or if they have a drain pipe that runs out right in front of the door that creates the ice right there in front of the doorway, then that's more likely to create liability that a jury's going to find, yes, they're at least partially, if not totally, responsible for this injury. Whereas if it just started sleeting 10 minutes before and they didn't have time to do anything to correct it, then the jury's less likely and probably is not going to find liability in that situation. But it's going to, those cases are going to be extremely fact dependent.
But in all reality, the business owner, the manager, the supervisor, whomever, needs to take some corrective action. And a lot of times when it's raining or snowing and sleeting outside, putting the safety mats down, hey, you can wipe your boots on this as you come in the store. Part of the reason they're doing that is not just to keep the floors clean, but it's a question of liability.
Exactly. I believe that is a big part of why some do that from that standpoint. And I think that's part of the reason the law has evolved in Kentucky, and I'm glad that it has evolved in Kentucky, because the law, when I started practicing law, basically was, if you don't do anything, you have no liability. If you try to do something, then you may have liability.
Right, you made it worse, actually.
Yeah, so it was, but the law encouraged business owners not to try to make their places, their parking lots safer and sidewalks safer for customers from that standpoint. So I think the advancement in the law has been a good thing, in that it does now at least encourage business owners to take corrective measures to make it safer for their customers.
Well, and again, I'm going to credit you and your profession. Part of the reason people pay more attention to this now is because there is the potential threat of a lawsuit out there, so they are a little bit more aware of these situations. And I know sometimes people like to make a lot of lawyer jokes, but really the world's a safer place because there are people such as you, a plaintiff's injury attorney, who's willing to hold somebody accountable for those things.
Yes, I agree with that, and I think
I thought you might.
Yeah, and I think the evidence bears that out from that standpoint. And I've been in parties to conversations. I've been where people would be talking about something, and of course they know I'm an attorney, and they would say, well, if we don't do this, and somebody gets injured, we can be sued. And so, isn't that right, Jeff? And I would look at them, and a lot of times I've said, and I think I've irritated a few people, and I said, that's true, but I would hope you would do it so nobody would get injured, not because you're concerned about a lawsuit.
Yeah.
And I suspect everybody that listens to this podcast has probably heard somebody say, well, if you do that, you may get sued for it. And talk about if somebody gets injured by it, it's like, well, maybe they shouldn't do it because somebody's going to get injured by it.
Right. The world would be a better place if that were the ultimate motivation.
Exactly.
I would think.
Yeah.
So premises liability, we've talked about items falling off of a shelf. We've talked about slippery substances that can happen. We've talked about adverse weather out in a parking lot and coming in and out of stores. This can also happen when you're in a plant and there's a chemical leak of some sort. And then I guess we're getting back more into comp at this point. But I'm thinking about like where you might have a gas leak or something like that, such as a chlorine leak or something like that, where now I suddenly have a respiratory injury. I've messed up my lungs because I'm inhaling this. Let's take it out of workers' comp. I'm not talking about somebody in the plant, but people around the plant who are now affected by something that happened.
Right, and that can be, if you're exposed to a hazardous chemical in a facility, and you obviously if you're an employee, then you've got a workers' compensation claim, not a personal injury claim. But if you're what is what in legal terms is called an invitee, you're on there for the other person's business purpose.
The sales reps come on to do a meeting with the purchasing manager.
Yes, something of that nature. Then yes, then there very well could be a third party claim or a claim against that business for that leak. A mailman's in there delivering mail, and they have a chemical leak that causes respiratory distress. Then that male person would have a potential claim, would have a claim against that business in that setting.
Right.
And
I bring that up because from time to time you'll hear about these things, and you don't really think, well, that nobody's necessarily responsible. No, there is a way to track that back, and if it can be proven, especially if you have some damages, especially medical damages, it's important that you do sit down and talk with a qualified attorney.
Right, in any of all of these cases that we're talking about, to have a claim against the business owner, the residence owner, they have to be negligent in some form or fashion. If they're not negligent in causing the injury, then there is you don't have any recovery from that setting. So we're not talking about a situation where if there's no notice to them that they didn't know about it and they should not have known about it. There's no reason they should have known about it. Then they don't have liability in that setting. It's got to be negligence on the business owner or the resident, whoever owns the premises part or rents the premises. They have to somehow be negligent before you have a claim against them for damages.
Right, and that's really where the issue is that you should have fixed it. You should have addressed it somehow, whether that's marking off an area, the cordoning off an area, or evacuating an area, depending on if it's substantial enough.
Right, and one of the things that you see when you're talking about that you see a lot, and this is more of a property damage instead of personal injury, but if somebody on their property, business, or residential has a dead tree, and the tree's been dead for 5 years, and a limb falls off that dead tree and strikes somebody's car or strikes a person, the person's on notice that the tree was dead and they should have done something about that from that setting. Whereas if lightning strikes and hits the tree, and part of it falls off, there's no liability on the
You couldn't have
property.
foreseen that happening.
You couldn't have foreseen that happen. They had no knowledge that the lightning was going to strike that tree or anything like that. So, they're not negligent in that setting. There's no claim there. It's just, unfortunately, it's just, accidents happen type situation there. It's not anybody's fault.
Right. So, I think one word of advice that if you're listening to this, you might take home with you is that, if there's ever a question, you should at least call an attorney. And if you're dealing with a personal injury attorney here in Kentucky, then it doesn't cost you anything to engage with that,
Then
right?
you should call Jeff.
But seriously, Jeff, talk about how, sometimes you don't know if I have a legal issue here, and if it's related to an injury. Does it cost anything to call you and just have that conversation?
No. Initial consultations are free, and I sit down a lot of times with people and talk with them, and when we talk over the situation, there is not any negligence there, and I tell them, I said, I don't think the person was negligent in this situation, and so I don't think there's anything I can do for you, and so but I will also talk with them about other things that they may be able to do to help cover medical bills and things of that nature.
Right. I mean, you've got an experience in that area, and a lot of people just don't. So it's nice to have somebody they can actually recommend.
Exactly. But and if they come in and talk to me that first time, and if I tell them, I don't see a case here, and I will always tell them, talk to another attorney. Attorneys disagree on these matters. Somebody else may see something I don't see. But if they come in and I tell them that, there's no cost whatsoever to the individual for that. The initial evaluation is always free.
Wow, and that's fantastic. But it's another way that here in Kentucky you have access to the legal system. That if Jeff, if you were charging on the hour, for an injury case, that wouldn't be, I may not be able to afford that. But again, the way your office operates is on a contingency fee basis. And I know we've talked about that in other situations, but talk about a contingency fee, because I always think it's important to underscore this, because I hear people talk all the time. Well, I'm worried about, the attorney's fees or how much it might cost. Injury law is different from other areas of law.
It is, and it's the one of the reasons why it's different is because most individuals who are injured and are out of work, they're struggling to pay the bills that they already have. They can't take on another bill, a lawyer's bill, to pursue that claim. So myself and other attorneys who do personal injury work handle the cases on a contingency fee, and what that means is the fee is contingent upon the recovery. If we are successful, we get paid an attorney fee. If we're not successful, we don't get paid an attorney fee in that case. And the percentage is tied to the result that we obtain for our client. It's a percentage of the of what we recover for our client. So the better I do for my client, the better I do for myself. So I would have an incentive to do the best for my client in that setting. Now, the percentages vary based on the type of case involved. One type of case, the percentage will be lower. They're usually the types of cases that are less complicated, less expensive to pursue. The more complicated, the more expensive to pursue. Then the percentages go up in that from that standpoint. Myself and some other attorneys also advance litigation expenses, and those are also contingent upon recovery. So that's the cost that I incur or another attorney incurs in representing the client in the claim. When I write to doctors to get their medical records, they charge me. Well, if I go take a doctor's deposition, have them fill out a report, they charge me. If there's other experts I have to hire, I pay all of that cost. All of that's also contingent on recovery. So if I'm successful, I get paid my attorney fee and reimburse my expenses. If I'm not successful, the client's not out a penny.
And I think that, again, that right there, what you just said, is very important to understand, that, the attorneys are required to say court costs and other expenses are the responsibility of the client. But should you not prevail, should you not win the case, you absorb those costs. You don't actually send those forward or invoice the client for those expenses. That was really on you, right?
Correct. Yeah. If we're not successful, the client doesn't pay me anything from that. That I do not get reimbursed my cost. Now, I do want to clarify one thing, because I do handle some hourly rate work here in the office, so I'm not exclusively contingency fee. But when I'm handling a personal injury claim, where we're looking at recovering money damages for my client, that is handled on a contingency fee. The client's told up front the very first meeting, or the meeting when they hire me, to that I go through the contingency fee agreement with them. At that point, when they come in to see me the first time, I talk to them about what the percentages are going to be. From that standpoint, but we go through that retainer agreement, and they'll sign a written retainer and get a copy of that retainer agreement, so they know up front what everything is.
Right. There's clarity there, and I think that's important. Sometimes you wonder, well, what didn't you say? Well, no, it's right here on paper.
Correct.
And as an attorney, you're bound by that contract, obviously.
Yes, absolutely.
Yeah, I think that makes a lot of sense. Jeff, I know premises liability is kind of an odd topic in terms of it's something that some people are familiar with, many others are not, but it doesn't mean they're not going to incur it at some point, especially with the the popularity of some of these bigger stores and even in your local grocery store. I mean, it can happen. It can happen in your local convenience mart, where something's on the floor and you just didn't see it.
Yeah, and I'm seeing, at least it appears to me when I go to some of these retail establishments, fewer and fewer employees working in the establishments. And unfortunately, I think that's going to lead to more and more premises liability claims, because when there is a spill in the floor, it's less likely to get seen and cleaned up as quickly as it should be from that standpoint, and also from the same standpoint of falling merchandise. If you don't have another employee to block off and make sure no customers are in the other aisle, and something is hit, and it's more likely somebody's going to get hurt in that setting. Whereas if you got that aisle blocked off, then nobody, even if you do knock something off, nobody's going to get hurt.
Right, and that's just, you got to be aware in these situations. A lot of times we zone out. We like to be on our phones. We're walking up and down the aisle. Maybe we're having a conversation, and we're not looking around. But these areas are inherently dangerous, and you may not think about it, but maybe if you've listened to this episode, maybe you'll begin to kind of look up once in a while and understand, okay, wait a minute, I need to be a little careful here.
Yeah, exactly, and that gets back to Kentucky being the peer comparative, which, and I'm a big believer in individual and personal responsibility, but I'm also a believer in corporate responsibility as well, which to me are hand in hand. If the person does something to cause their injury, or is 50% responsible for their injury, then they shouldn't get that 50% of damages that they caused. But the other person who caused the other 50% should be paying those damages if they're negligent from that standpoint. So, that all kind of, in my opinion, goes hand in hand from there. And I'm, Kentucky, a lot of states I think have gone. I don't look at other states since law school. I really don't care because I don't practice in those states. But I know, at least when I was in law school, more and more states were looking to go to peer comparative, and I think that's the best way to handle it. Some states had what was, whereas if the at-fault party was 50% or 51% responsible, then not the at-fault party, the injured party was 50% or 51% responsible. They didn't get any of their damages, which was basically a windfall to the negligent party, in my opinion.
Right, and at some point that can be very, very subjective as well.
Always
determining that percentage of fault. Right?
Always will be subjective. It's up to the jury to make that determination, and you present the evidence to them, but you can present it to 12 jurors in one courtroom and the exact same evidence, 12 jurors in a different courtroom, and get different answers.
Right, right. Jeff, thanks for your time. I appreciate it. And I hope somebody out there has heard this and has realized, well, wait a minute, I need to talk to either people in my family or at least be aware when I'm going into these retailers, and just be a little careful. We'd like to see you at Kroger, not litigate on your behalf because you went to Kroger.
Absolutely. I would rather you
Nothing
be safe.
against Kroger. I like Kroger.
I like Kroger as well, but I would much rather see you at Kroger and say hi to you than see you in my office because you got injured at Kroger.
Yeah. All right, my friend. All the best.
Thank you.
See you. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.